Hello and welcome. My name is Olivia Ash. After watching this video, you'll understand the duties of a fiduciary of an ERISA benefit plan. If you are currently designated as a fiduciary, it's a big deal. Did you know that even if you aren't designated as a fiduciary, you may be one based on your job functions? But no fear. We at Compliance Dashboard want fiduciaries to avoid pitfalls leading to costly penalties. Let's get started. Why do we care about fiduciaries? The Employee Retirement Income Security Act, otherwise known as ERISA, sets standards of conduct for those who manage employee benefit plans and plan assets of private sector health plans, not government or church plans. And the people who manage the plan? You guessed it, fiduciaries. If you make plan decisions, this could be you. What is a fiduciary and who is a fiduciary? An ERISA fiduciary is any person who exercises discretionary authority or control over plan assets or administration, or gives investment advice for a fee. Any person can be a fiduciary, and sometimes they're unaware of this duty. If you exercise discretion or control over plan assets, you may be a fiduciary. To exercise discretion means you make independent decisions regarding the plan. Beware, ERISA regulations permit courts to decide whether a person's actions are considered fiduciary in nature based upon that person's functional duties. This means that a person who functions in their job as if they were a fiduciary will likely be considered one for legal purposes. This also means a mere job title on documents does not excuse responsibility. Essential duties of fiduciaries. A fiduciary must act solely in the interest of the participants and their beneficiaries. Prudently carry out their duties. Follow the terms of the plan. Hold plan assets in trust or with a licensed insurance company. And pay only reasonable expenses of the plan. A common theme within each of these duties is the concept of prudence. Prudence is a fancy way of saying a fiduciary must take care in doing something, or, in other words, use caution. What is a fiduciary act? A fiduciary act is any act related to the administration or decision-making of the plan. For example, managing the money for the plan, modifying or transitioning a plan, and decisions made during the process of denying eligibility are all fiduciary acts. A word of caution. A fiduciary may be held personally liable for a breach. Yes, that's correct. A fiduciary may pay from their own pocket if a breach of duty occurs. To avoid fiduciary pitfalls, practice these 5 tips. Tip number 1. Carefully monitor and select plan providers. Fiduciaries must pay attention to detail. Document decisions and the process of deciding. Read the fine print when choosing providers and making plan decisions. A fiduciary must make plan decisions with the care, skill, and diligence that a person familiar with such matters would use. This is a high standard. There are no degrees of fiduciary status. If you're unsure about a plan decision, ask for help. Ignorance of plan details or saying, "I didn't know," won't fly as an excuse during a Department of Labor investigation. Tip number 2. Ensure plan participants and beneficiaries receive required disclosures. SPD stands for Summary Plan Description. This is a federally required plan document. Typically, it must also be written so the average plan participant understands it. It must also be disclosed in a format likely to be received by participants. This means it may be insufficient to only send SPDs electronically. A best practice? Require employees to sign off on receipt of their SPD. And remember, to include a penalty, no harm is required. Simply failing to distribute the SPD and other required notices will incur penalties. Tip number 3. Know your plan and your responsibilities. For the protection of both plan fiduciaries and participants, a fiduciary must know plan details and follow the plan document. When in doubt on a plan decision, consult the plan documents. If details are unclear, ask for help. Last, learn the claims process to assist you in making the best decision. Tip number 4, make timely contributions and monitor plan assets. This is simple. Treat plan assets as you would want your money treated. Treat it well. Plan assets are someone else's money. And tip number 5, maintain accurate records and file your reports on time. It's not enough to know the plan document, claims procedures, and distribute required notices. To avoid breaches and possible fines, fiduciaries must also create and maintain accurate records and file required government reports in a timely fashion. The Department of Labor looks not so much as whether harm was caused by a plan decision, but at the implementation of plan decisions. When dealing with the government, remember it's best to be candid, transparent, and act in good faith. Our time is up. Remember, a fiduciary's duties are the following. First, to act solely in the interest of plan participants and their beneficiaries for the sole purpose of providing benefits. 2, to prudently carry out those duties with care, skill, and diligence. 3, to follow plan documents. If you don't know what it is, ask. 4, hold plan assets in trust. And 5, pay only reasonable expenses. Thank you for listening.